and hand over to our guest speaker. Can we give a big Berklee welcome to Dr. Katherine Leo?
Hi, everyone. Thank you so much. I'm delighted to be joining you, and even more delighted for the rare opportunity to speak without a mask on today. So, of course, at Millikan University, we are teaching in person and learning in person, but we are wearing masks, which is a challenge, as you've discovered. So I'm thrilled today to be able to talk with all of you. If you see me looking down today, I'm either checking all of my technology or I'm looking at my notes, and I have many pages of notes. So that's what I'm doing. If you haven't noticed thus far today, I do tend to talk very quickly. And so if there's a break in the connection or something doesn't come through clearly, just give me a signal and I'm happy to repeat anything that I say. So for the past 7 weeks, you've been cultivating forensic analytical skills. And today we're going to start putting them into context. So I know this is not a law class, and I know it's not a music history class, but those are both of my specialties. So we're going to try to do those today, but of course, taking your analytical skills and putting them in the context of history and law. So let me screen share, and hopefully I do this right so that the audio comes through as well. Are you seeing slides or are you seeing a Zoom thing? Seeing slides. Yes. Okay. This is good. All right. So today's topic is going to be listening as legal fact finding, and we're going to be thinking about audience and the audience for forensic similarity analysis. Now, let's dig in. Okay. So most forensic musicology, as you've learned for the last 7 weeks or so, happens actually outside the courtroom. So we know that we can do consulting for ad agencies and for record labels, or we might get contacted by a musician or an attorney who wants a preliminary analysis. Is this worthy of a lawsuit? Should I sue over this or not? That sort of thing. And so we're familiar with this idea. Now, studies vary and their estimates vary, but roughly 80 to 90% of lawsuits settle out of court. And so the majority of forensic musicology, even in the context of a lawsuit, happens outside the courtroom. And that's problematic for scholars like me, because when a case settles outside of court, there aren't public records of it. And so it's hard for me to get a hold of records for the dispute and be able to study it. And so the majority of legal disputes over music copyright are very difficult to trace and very difficult to study. But among that 10% minority that do make it to court, that's what we can study. That's what we can look at with the records. And we can start to think about how we as a society understand music as property. So today we're going to be thinking about what happens when forensic musicology heads to court, goes to trial. Now, no matter what kind of analysis you're trying to do, you should always be thinking about audience. And this actually is true of any kind of writing that you do. Always think about who you're trying to write for. Who's your audience? So today we're going to be thinking about the audience in a copyright lawsuit case or a copyright trial, those are the fact finders. Those are your jurors. Those are your judges. So the big takeaway point for today is how to think about audience and how we can use our analysis to help our audience. So we're always thinking about first, who is our audience? Of course, in this case, it's fact finders. What they need from us as forensic musicologists, and 3, why they're looking to us. Now, of course, we know the answer to the last question. That's we're in a copyright infringement lawsuit and we need an answer. We need to make a decision. So of course, they're looking to us for that reason, but we need to think about all those questions when we're preparing some kind of analysis. So today we have a full agenda. So we'll have to put our roller skates on. This is very similar to musicology classes at Millikan. We do a lot with our time. So we're going to start off by reviewing Ernstine and Porter versus Porter, which you talked about last class and you did some reading on. We'll look at the facts of the case and the outcome, of course, and see how much you remember from reading the opinion. I will also step aside for a minute to give you some tips and tricks for reading court opinions. So there are actually secrets for making court opinions easier to read. So we'll talk about that a bit. Next, we'll examine the decision-making process for infringement lawsuits. what the origins are for the Arnstein decision and the Arnstein test, and then of course the role of experts and non-experts in that process. We'll also think about why the Arnstein judges came up with it, why the test is the way it is. And then of course, we're going to get a chance to discuss. We'll listen to some musical examples. We'll talk about some research on non-expert fact finders, and we'll try to see if we can come up with some solutions to the problems that are inherent in music copyright infringement lawsuits. So today is more of a critical thinking day, a little bit less of a musical analysis day, but we are starting to build some skills that hopefully you can use in your projects and your presentations for the rest of the semester. So at this point, I invite you to take notes or simply to listen carefully, whichever you prefer. But please feel free to ask questions at any point in time, and I will try to make sure to look over at my screen periodically to see if there's hands raised, or Professor Bennett, Joe, jump in and let me know if there's a question, and I'm happy to answer at any point. All right, so let's dig in and do some review on Arnstein versus Porter. Okay, so even before we dig into Ira Arnstein or Cole Porter, most copyright lawsuits unfold following a similar pattern. And so whenever you're looking at a court opinion, chances are the parties and the dispute are very similar. So most commonly, the plaintiff or the person suing is going to be a songwriter, of course, probably less well known. And they're going to be suing a defendant, another songwriter, who's probably more well known. And the claim, of course, is the defendant took something out of my song as the plaintiff. And so, of course, we remember from Arnstein versus Porter, Ira Arnstein, he fits this pattern. He's the New York City composer, pianist, performer. He's slightly unhinged, right? He's suing in 5 different lawsuits. He sues over 50 defendants and 60 different songs, all claiming all these famous composers stole my ideas from my music, right? And so we remember this, and spoilers, he loses all of his lawsuits. But in any case, if you're really excited about Ira Arnstein, there's a whole book about his lawsuits and his life. It's called Unfair to Genius. It's by Gary Rosen. So again, the title of the book is Unfair to Genius. If you're really excited, you can read that and check that out. It's a great book. It's beautifully researched. So there's that. Now, the last lawsuit that Arnstein's involved in is Arnstein versus Porter. And that's the one that matters for us in forensic musicology. All 5 lawsuits are interesting and they all have their own idiosyncrasies, but the one that matters, that is important for our purposes and important for copyright history, is of course Arnstein versus Porter. So this time we remember Arnstein sues Cole Porter. Right, so it's his last lawsuit. And so it's heard first by the trial court or the district court in the Southern District of New York, because this is a federal case. And the outcome is actually somewhat shocking. So during the whole discovery process, collecting of evidence, getting ready to go to trial, there's very little evidence that Arnstein can produce to demonstrate that Cole Porter stole music, his very famous songs, from Arnstein. And so by the time the district court judge or the trial judge gets to writing his opinion, he only writes 1 paragraph, which, as you know from reading MCAR, that's shockingly short. Judges are never that concise. But he says, you know what? I'm not going to waste my time with this case. Like, he knows the backstory with Arnstein. He knows what the other 4 lawsuits look like. And he says, you know what? There's not a ton of evidence here to prove anything. I'm not going to waste my time with this. It's dismissed. That's it. I'm going to focus on more pressing cases. And so, of course, as you might imagine, Arnstein is super upset about it, and he appeals to the Second Circuit. And so that's where we pick up and where you picked up last time. But before we dig into the Second Circuit opinion, here's a quick little chart that I made and is in an article that I wrote from a few years ago that connects the songs that Arnstein wrote with the Cole Porter songs that Arnstein claimed stole from his own music. Now, last class, you looked at a different pairing of these songs and started to talk about Arnstein's strategy for trying to demonstrate similarity. So all of these pieces are actually on the MCAR website with audio. And so we're going to be using that kind of low quality MIDI audio. I apologize, but it'll do its job. So in any case, you've already kind of experienced how Arnstein tried to claim similarity, right? He sort of cherry picks little different sections that, surprise, are similar. So the pairing that we're going to look at is I Love You Madly with Night and Day. And the reason why we're looking at this pairing as opposed to any of the others is because this is one that the court focuses on. So the court says Porter's Night and Day opens with a repeated note that drops a whole step, then drops 2 half steps, then back up a whole step, or excuse me, back up a half step. And then Arnstein's refrain. So right there, this is like breaks screeching to a halt. It's the beginning of Night and Day is compared to Arnstein's refrain, Arnstein's chorus. So we're seeing Arnstein cherry picking little details from different formal sections of the 2 songs. So allegedly, the chorus of I Love You Madly opens with the same progression. And so we're going to listen to these just to get our ears a moment of reminder of how Arnstein is claiming these somewhat spurious or silly or ridiculous or unfounded claims of similarity. So we're going to listen first to I Love You Madly. And now to the beginning of Night and Day. Again, this is the MIDI recording off of MCIR. Okay, so even on a quick listen, not taking time to transcribe or really focus in specific detail, there's not a whole lot to say about these 2 recordings. There's not a ton of similarity between them. In any case, the Arnstein cases led Cole Porter's, and specifically this case, led Cole Porter's expert witness, his name is Sigmund Spaeth. We're going to see a publicity picture of him a little bit later, to advocate in court for an integrated approach to forensic musicology. And that's the technique that you're learning how to do in this class, right? We have to think about all these musical elements in context of one another. You can't just cherry pick what you want from wherever in 2 songs. They have to make sense and be in like similar formal sections or have similar rhythmic situations with pitch. You can't just think about pitch or just think about rhythm or just think about a harmonic progression. All of these things need to be considered in context. And we know this, but this was a big part of Sigmund Spaeth's advocacy as an expert witness. Okay, so the case does go on to the Second Circuit. Okay, the case goes to the Second Circuit. And when a case goes to an appellate circuit or to an appellate court, there's a 3-judge panel. So 3 judges hear the appeal and then they decide. And so that's why when you're looking at appellate opinions, often you'll see a majority opinion and a dissenting opinion. So 2 people agree and then the third judge decides to write the dissent or the opposite opinion. It's possible to have a unanimous opinion, but more commonly, you're going to get a 2 versus 1, a majority and a dissenting opinion. So in Arnstein versus Porter, the case goes to the Second Circuit, and the decision is to reverse and remand. So reverse means we're going to change the decision from the lower court, the trial court, the district court. All 3 names are for the same thing. So district court, you got it wrong. We're going to reverse you. But what we're also going to do is remand. And so what remand means is that the appellate court is going to say, you decided this incorrectly, lower court. Here's what we actually want you to do. Here's the process you should have followed when you made this decision. And so at Arnstein versus Porter, the majority lays out a process for deciding copyright infringement cases that the lower court is supposed to use. But that decision-making process becomes extremely influential for the next all the way 75 years up until the present day. So now, spoilers on Arnstein versus Porter, perhaps not a spoiler. Porter eventually wins on remand, but that's neither here nor there. The issue is how we know. And of course, the court opinion is the place that we're going to find all this information. Now, as you probably discovered on the MCIR website or anywhere else you're reading court opinions, they're often long, they're often dense, and they're often full of lots and lots of legal jargon. The reason why these cases are that way, why aren't they just written in plain language? It's because these cases are common law. So common law is used by future lawyers and other courts in order to figure out the resolution of future disputes. So a lawyer is able to go back to that opinion, read it carefully and say, is this similar to my case? So I can say, hey, look, judge, we should do it the same way as this previous case did. Or does the attorney look at it and say, you know what, this fact pattern is totally different from what's going on with my current client. So I need to make sure the judge doesn't look at this case. No, that's not relevant here. We don't want you to use that process for decision making. So for that reason, court opinions are very formulaic. They are formulaic so that it's easy to read them and it's easy to find the information. But that's good for our purposes because you can set up a system for how you go through an opinion and you know where to look to find the information you're looking for. The secret here is you don't actually have to read every single word. Should you? Yes, but there are places where you can skim. So the next tip to consider when you're going through a court opinion is to draw a diagram. And I promise you, practicing attorneys actually do this. They do, as they're reading, they keep a list of all the facts. They do draw a diagram because it's very rare for a court case to be simple. The simple cases get settled out of court. Right? There's no interesting problem that courts need to solve. So they settle. The complex cases are the ones that go to court and end up in the court opinion. So when you're reading those fact patterns, draw a diagram. Another issue with court opinions is often the language can be very vague. Courts will usually use the words plaintiff and defendant instead of the actual names of the parties. That's to help out the attorneys in the courts. I'm representing the plaintiff, I'm representing the defendant, and so I can quickly read this opinion and see, is the similar party in this case doing the similar things to what my party is doing? Go through, X out all those plaintiffs, X out all those defendants, whether you have it printed out or you've got your beautiful magic iPad and you can scribble on top of it. Write in the name of the party so that you're able to read through and keep track of who is who. So there's a formula that goes into these case opinions. Most cases will start with a summary. Now, if you're looking on MCIR, of course, you know that there's the commentary that is right above the actual opinion. A word of caution on that, because often the commentary can be biased. And so you don't necessarily, even if I'm the one writing the commentary, it might actually be a little bit biased. So if you read it skeptically, but instead think about just jumping right to opinion by Judge so-and-so. So in this case, the example up on the screen in tiny, tiny print is Judge Frank. So we're going to start off with this summary. This is the summary of the case and the outcome. Again, it's supposed to be helping out the judges and the attorneys by saying in 1 or 2 sentences, here's the parties, here's the main question that we dealt with, here's the outcome. okay, so I, as an attorney, can make a decision quickly. Should I keep reading or not? Is this relevant to me or not? Unfortunately, for our purposes as forensic musicologists, the summary isn't always helpful. So you can skim it. Sometimes they are, sometimes they're not. Skim it for sure. The very next paragraph in this particular opinion, sometimes it's more than one, sometimes it's a little bit lower down, but often the next critical portion of a court opinion is procedural law. Procedural law will resolve any kinds of civil procedure issues, how the court case is going to unfold, what the standard of review might be for the judges, if there's a jurisdictional issue. These are questions that can matter if you are an attorney. For our purposes in forensic musicology, they don't really. They very rarely change. Very rarely do they make a huge impact on analysis. And so that's a section actually you can skim. It's interesting. And if you're thinking about a career in music copyright law, definitely check it out. And otherwise, just skim it and move on. We can go down a few paragraphs before we actually need to start reading. So right after the procedural section of a court opinion comes the facts and the questions that the court is actually going to answer. So the court will outline very clearly what the question is that has been brought forward by the plaintiff, the person bringing the lawsuit, and what it is they want resolved. As you might imagine, in most copyright lawsuits, the question is going to look somewhat similar. Of course, does this constitute copying? Did so-and-so copy from so-and-so? That sort of thing. And then following, we'll outline the facts of the case. This is the place where we draw the diagram. So-and-so wrote their song in 1972. In 1976, it was brought into a movie. In 1978, the defendant wrote a song that sounded kind of similar. And so that's how we ended up here in court. So that's going to be really important for you to get context of what's going on, where the dispute is. It's also an interesting place where you can find some music analysis. So this is a sneaky little place that expert analyses can show up in opinions, because the court wants to start to explain what parts of the songs are involved in the case. So the melodies from the choruses, or the harmonic progression is similar, the meter and the key are similar, the melodies are similar here and here. You might get a little bit of analysis mixed in. So it's a good place to look if you're simply interested in analytical issues. So often judges through this section will use plaintiff and defendant. Again, cross those out, write in the names of the parties. It makes it easier to read. And law students do this all the time, and so do attorneys. The next thing and the next part, this is onto our second page. So I scrolled down in the opinion on MCIR, a good 4 or 5 paragraphs. The next section is the relevant case law. This is where the judges are looking at cases that came before and how similar cases were decided in the past. This is where those copyright case decisions come into play. Now, this is also where you're going to see a lot of citations and the big long string citations and lists of cases. You can skim those citations. The only reason they matter is if you're someone like me who wants to see how an idea unfolds over time. Otherwise, you can skim those. The reason why it's important to read this section about case law and reasoning is that that's where the judges are going to grab their keywords. Words like substantial similarity, words like striking similarity, like lay listener, or dissection. These are little words that are going to become keywords or criteria by which the judge is going to make the decision. So it is kind of hard to read this section. It gets somewhat dense, but especially in direct quotations from earlier court opinions, you're going to see little keywords that start popping out. And those are going to be used throughout the rest of the opinion. And if you follow how the judges use those words, you can see how they're reasoning and figuring out the outcome of the lawsuit. So then the final section that you want to pay attention to is the application and the reasoning, how we're going to use those vocabulary words, those keywords, as applied to the facts specifically in the case. So this is the interesting part for legal scholars because it's where the new laws appear, but it's also interesting for us as music analysts because we'll see more music analysis showing up in this section of application as well. So every court opinion will follow a similar process. So you don't actually have to read 1,000 opinions to become an expert on how to read them. You know where to look, where to find the musical analytical sections, and how to cope with those really jargony sections of law. Now, there is one thing to look out for when you're looking at a court opinion, and that's dicta. Too much technology today. I decided to put animations in my slides and then they're not loading. It's fine. Anyway, dicta. So dicta refers to commentary from judges that's not law. And it can be really confusing because it'll show up anywhere. And really all it is like a rhetorical device or the judge trying to have some fun, be a little sassy, a little humorous. It's just part of their writing style. It doesn't matter to the court case, but it shows up all the time. So for example, in the Arnstein versus Porter case, there's actually two really great examples of dicta, one of which I've marked out for you in tiny, tiny print. So I will summarize. So there's a really critical statement that the majority makes, that Judge Frank makes about music analysis. So he suggests that expert analysis, forensic musicology, forensic similarity analysis is like caviar. So it's really high class. It's an acquired taste. Maybe some of you love caviar. Maybe some of you are really suspicious of it. But either way, you know it's kind of an acquired taste. You're going to have to learn to like it. And so what he means here, of course, is expert analysis is somewhat suspicious. It's not for everyone. Fine. And so he's got this cute little metaphor going, but he extends that metaphor to even describe the aesthetic value of the songs involved. And the end of the little dicta section says, but the plaintiffs and defendants' songs are not caviar. Now, this is a big no-no because it's introducing an aesthetic judgment. Are the songs good or not? And that's completely not what's supposed to happen from a judge in a copyright lawsuit. And there's precedent for that, tracing all the way to the early 20th century, except it shows up here. Does it matter to the outcome of the case? It does kind of give us a little peek at the opinion of the judges about the whole situation, but it's not law. So you can ignore it. It's called dicta. It shows up. There's another example of it in the dissent, which opens with a quote from the lyrics of Night and Day. So the beat, beat, beat of the tom tom. That's the opening of the dissent. It doesn't mean anything. It's not important. It's not drawing attention to any kind of comparison. It's just trying to be clever or rhetorical about constructing the opinion. And judges love doing this. They think they're hilarious. And sometimes they are, rarely. So when you're reading these opinions, beware of dicta. This is a place where you can draw a big line or a big X through because it's not really helpful for understanding music analysis. And it's not really helpful when we're looking at the outcome of the lawsuit. Okay. So let's dig in a little bit further to the Arnstein opinion and look at what they came up with. So the three-judge panel comes up with the opinion that you read last class, and they reverse and remand. When they remand or send the case back to the trial court, here's the system that you're supposed to follow. And this is a big start in your notes moment for today, because this is the test that we often call the Arnstein test that's used for deciding infringement in infringement cases. And there are various manifestations of various versions of this in different jurisdictions across the US now, but it's always a variant of this for the last 75 years. So, and no one has ever tried to 100% overturn this decision-making process. So in order to prove copyright infringement, step one, you have to establish valid copyright registration. Just fairly straightforward so far, right? Now, there, of course, are places where there could be lawsuits over whether or not the copyright registration is valid, but we're not going to talk about that today. So we're going to assume that there is a valid copyright registration. The second step is you have to prove copying. That's where our forensic musicology digs in. And of course, if you have the valid registration plus copying from it, you get infringement. So in order to prove copying, we have two options. Option one, you could have direct evidence of copying. This is rare. This is very rare. And what ends up happening, it does happen on occasion. Either the defendant admits they copied, so the lawsuit is about something else, or we have to use a different system. Now, before we get into that different system, if a defendant actually does say, you know what, yeah, I did copy, usually either the lawsuit is about damages and how you're supposed to pay the plaintiff, or we get into a fair use situation. I only took a little section, a 3-second sample. I was doing it for a class, so it's educational use. The section that I used was done as a parody. So it was supposed to be a joke, and it's really obvious to everyone that it was a joke. So I should get away with it. It's not actually infringement, it's fair use. Okay, those are rare. What more actually commonly happens in infringement cases is that we have to find a balance between access. So in this situation, did Cole Porter actually have access to Ira Arnstein's songs to copy from them? Even setting aside the whole spies issue, fine. Did he actually have access to the songs to copy them? And are they substantially similar? So in order to prove the last part, substantial similarity, we have a 2-step process. Step 1, expert analysis. That's where you come in. So courts assume that, and when I say courts, I mean judges. Courts assume that the analysis that forensic musicologists produce is objective, right? It's scientific. That's the forensic idea. It's supposed to be unbiased. Right? And so this is where our analytical skills kick in. We're supposed to be providing close comparisons, usually taking into account melody and harmony and rhythm and form and lyrics, all in the context of one another. Fine. Now, experts are allowed, they produce reports. They often are called early in the litigation process, and they can continue forward all the way to the conclusion of the lawsuit. They can use diagrams in their reports. They can also use diagrams at trial. So if there's jurors, you can draw a picture for the jurors to help them understand. That'll matter more later on. So while forensic musicologists are allowed to comment on copying, yes, there are similarities. Yes, this suggests copying. They are not allowed to comment on if the copying constitutes infringement. So as a forensic musicologist, you can't tell the court, yes, this is infringement. You can only say, absolutely, there's high proof of copying. Because the people that make the decision about infringement are actually not experts. Those are the fact finders. And so in the second step, that's where our jurors come in. And in rare occasions, a judge only, you can request a judge only trial. It's rare. More commonly, you're going to have jurors. So the second prong of this substantial similarity test is where the jurors step in, the non-experts, and they're supposed to take a sort of totalizing approach to comparing. Do the two songs sound alike? And does that mean infringement? So that final step in the lawsuit is left for the fact finders. And so this is where your audience shows up as a forensic musicologist. These are the people that you're writing for. These are the people that you're supposed to be assisting in making that final decision about the lawsuit, because as experts, we're not allowed to comment. Now, there's a good reason for that, and in part because of one of the judges in the majority of Arnstein versus Porter, Learned Hand. And we actually saw his picture there. He's down in the right corner. That's Learned Hand. So Learned Hand was very suspicious of experts because experts tend to be hired by one party or the other. So are they really objective? Can they really be unbiased if they're being paid by plaintiff or defendant? I mean, we know that we can be that way, but you can understand the suspicion. And then, of course, if they're providing super detailed information that's not general knowledge, is it actually all that useful? These are big questions that we'll think about later on in the class period. All right, so there's our audience. Of course, this test and this idea that the non-expert fact finders should listen holistically, totalizing. Do the songs sort of kind of sound alike? Does it feel like they sound alike? This is built on an assumption that we as humans listen to music holistically. We get a general vibe, kind of like we look at faces. You don't focus when you're looking at someone's face only on their eyes. That's the only way you identify them. No, you identify their shape, you identify mouths and noses and ratios. We look at faces and we recognize faces holistically. We actually don't do that with music. And you can think about friends or family members, they may not be musicians, They're going to be able to tell you their favorite part of a song. They know the melody. They can sing along to it. They know that there's a guitar or a theremin, or there's a string section and an accompaniment, whatever. They can dissect a recording, and we don't actually listen to music holistically, except in 1946, the 3 judges involved in this lawsuit assumed that people do. And so that's why the test is set up so subjectively the way it is. More on that a little bit later. So the other issue that you might be seeing as you're looking at this diagram is that it might seem kind of redundant. In effect, we're comparing the 2 songs twice. Once we're doing it with experts and we're being super detailed, and then we're going to go back and do the same thing again, except just more generically, like broad, big picture. There's flaws here, right? And if you think about it, of course, outside of the false premises about experts and about non-experts, this test is created specifically in the context of an idiosyncratic lawsuit. So the test is created as a sort of slap on the wrist to the district court. No, you don't get to just dismiss a case because you're tired of the plaintiff and you don't have time to write the opinion. You can't do that. You have to go through every lawsuit fairly, equitably, and systematically. So here is the system that will force judges in the future to go through systematically and evaluate infringement. So there's a certain idiosyncrasy to this test that's specific to Arnstein. Had it come up in a different lawsuit with a different set of facts, the test might actually look a little bit different. Nevertheless, this is the test that we have. And so the process has been adopted by courts nationwide for 75 years. And it makes sure that experts are necessary and they have to be a part of the lawsuit because, of course, music is complicated, but they should be kept in check according to the courts. And so instead, non-expert fact finders are the ones that get the final say about infringement. So there's a good reason for all of this. The reason, of course, is economics. It has to do with economy. So here's the thing. US copyright law doesn't actually have any kind of moral right. So there's no idea that because I created it, it's mine. That exists in international copyright laws. The French system has a moral right, but the US system actually doesn't. The US system is entirely constructed based on economics. So when we're thinking about this, we're thinking compensation. I create a song, you write a song, you want to be compensated for that music. So copyright is designed to balance 2 competing interests. On the one hand, it's supposed to balance continued creation. So you write a song, and if there's no protection on it, anybody can steal it from you. Anybody can make money off of it. Are you really going to keep writing songs? Probably not. Maybe for a little while, maybe because you enjoy writing, but eventually you're not going to be compensated for this work, and everybody else is going to make money off of it and off of your work. So you're not going to keep doing it. So we need to come up with a system that's going to incentivize you to keep writing your songs. That said, it's extremely rare to write songs that are completely uninspired by anything else ever, anywhere. Right, so we want to balance the idea of continued creation and limiting access with ensuring that other songwriters can have access to your work. Maybe you want to borrow, maybe you want to pay homage, maybe you want to comment on another song that showed up, maybe you want to sample from it. So copyright is trying to make sure that it's possible that you can borrow some things, you can sample under the right conditions, so long as we're balancing that with making sure that songwriters are still going to continue writing their songs. It all comes down to compensation balanced with access. So another way to think about this is, of course, market share. There is a music marketplace that we learn about as music majors, and copyright is supposed to protect each songwriter's little corner, little share of the music marketplace. So you don't want a listener buying someone else's song instead of yours, thinking it's yours because they're so similar. So that's the issue there, right? Because you end up missing out on that compensation. So copyright, of course, is fundamentally concerned with the people that pay for the music, right? We're creating rights for the people that make the music in relation to the people that buy the music, that compensate and want to use it, which means audience. So for this reason, copyright, of course, is evaluated according to what's called a lay listener standard. These are the people in the market buying the music. So in other words, a lay listener is a hypothetical, ordinary human. This is your family member or your friend that doesn't read notation, that doesn't play an instrument, that doesn't have any musical training. They're an ordinary, regular person that will hear the songs as similar or not. So they are not trained musicians. And so it's with this reasoning that the Arnstein court, of course, comes up with its test. So about experts and lay listeners. Now, if you take a look at the picture up on the left of your screen, you'll see a fun little publicity picture of Sigmund Spaeth. He was known on radio as the Tune Detective. And so he's going a little camp here with his Sherlock Holmes hat. But anyway, the Arnstein court says the reason why they come up with this whole test, first experts, then non-experts, is that the proper criterion for deciding infringement is not an analytic or a comparison of the respective musical compositions as they appear on paper, or in the judgment of trained musicians. That's all of you. That's forensic musicologists. That doesn't matter. Instead, the court says, the question, therefore, is whether the defendant took from the plaintiff's work so much that is pleasing to the ears of lay listeners. But they give you a good reason before that. The plaintiff's legally protected interest, that means I'm a songwriter and my protected interest is in being compensated for creating my song, is not as such his reputation. That's a moral right as a musician, but his interest in the potential financial returns, again, compensation, from his compositions, which derive from the lay public's approbation of his efforts. This is really dense legal writing. It means compensation. If your song is good, people are going to buy it. And that's the point. You're supposed to be able to receive that compensation. So the question has nothing to do with elaborate musical analyses like we do in this class. It has everything to do with how ordinary people in the music marketplace are going to perceive it, and whether or not you're going to receive that compensation. So that's why the test is set up the way it is. Why lay listeners, why non-expert fact finders have the last say. It all has to do with economics. It has very little to do with any kind of morality or any deep suspicion about the Arnstein case. It has all to do with economics. So this is also why we don't see a ton of classical music lawsuits in the 20th century. If you've been looking at MCR relatively carefully, you may have noticed that there's not a ton of classical music lawsuits. There's actually not a ton of jazz lawsuits either, especially not after like the 1960s or 1970s. It's because the most lucrative and economically viable styles are the ones that end up in court. And so that's going to be whatever the popular commercial style is from the time. So forensic musicology in courtrooms is all about audience, this fact finder, non-expert audience. All right, so enough of that, enough of lecturing. Let's do some discussing and some listening. Here's the issue that we need to think about as we're moving forward. Actually, before all of that, we're going to listen to an example before we dig in. I'm getting ahead of myself here. We're going to do a little bit of discussing, and before we get too much further, we're going to do a little song listening, little comparison. So I'm going to play an example of two songs that were actually in a lawsuit, which we'll talk about more in a minute, that famously dealt with expert analysis and the issues between perception of experts and non-experts. So we're going to listen and then we'll talk about it. We'll see what you think. Are these songs similar or are they not? So this is when your analytical listening skills kick in. So here's the first song. This is the plaintiff's song. Okay, so that's our plaintiff song. Here's our defendant song. Is it similar or is it not? We'll take a vote in just a minute.
I felt like dying until you saved my life. Thank God I found you. I was lost without you. My every wish and every dream somehow became reality. When you brought the sunlight, come with my whole life. I'm overwhelmed with gratitude, 'cause baby, I'm so thankful that I found you. Oh yeah. Oh yeah. I will give you everything. Nothing in this world like you. To ensure you're happy.
Okay, so if I could get a little bit of help from our professor in the room, let's take a vote. So how many of us
Now,
say absolutely, these are totally similar songs?
so
Yes.
before you vote, I would say I'm not going to vote because we've discussed this offline and I have my opinion about this case. And we've talked about a bunch of is it or isn't. So please don't try and read the room or look to me or anyone else. Go with your heart. We've done a lot of this. Melody A, melody B. What do we feel? What's objective? The very same elements we've talked about. So I wonder, Dr. Leo, could you just play those two melodies for us again? So I know
Yes.
this team will be auto-transcribing them in their brain. But let's just hear the melodies again before we vote, if we may.
Okay.
Every time I wish that we were dancing slow, that's when I hear it playing on the radio. I know this is one of those love songs that you hear in the middle of the night. Makes me wanna be with you wherever you are tonight. And whoever's listening, just hold your lovers tight, 'cause this is one of those love songs. One of those love.
Okay, so that's our purple melody, melody A. Let's do melody B, green.
I felt like dying until you saved my life. Thank God I found you. I was lost without you. My every wish and every dream somehow became reality. When you brought the sunlight, come with my whole life. I'm overwhelmed with gratitude, 'cause baby, I'm so thankful that I found you. Oh yeah. Oh yeah. I will give you everything. Nothing in this world like you. To ensure you're happy.
Okay, we ready to vote? Okay, show of hands. Absolutely, these are similar. Yes. Okay, how many do we have?
I want to say 5, 6, 7 in the room, about half.
Okay, and then how many are like, no, not really, not so much.
Almost identical, and I infer maybe 1 or 2 abstentions. So about 50-50.
Yeah, absolutely. So you can see why this ended up in court. There's some similarity here, maybe. But hold your opinions, whatever you decided. Either way, there's no right answer. Keep that in the back of your minds. We'll come back to it. So we can imagine, of course, if we're going to be the forensic musicologist in this lawsuit, how we would put together our report, how we would go about transcribing and comparing and describing for the court what they need to know in order to make this comparison and make a good decision about whether or not this is infringement. So as experts, we're supposed to be helping the court, but here's the thing. The people we're helping are non-expert lay listeners, right? They're non-expert fact finders. So there are some issues, some recent research that's been done in the last 10 years or so that has looked at how non-expert fact finders perceive music. And this has introduced some problems for us that we need to think about when we're trying to help them make a good decision. So here's the thing. When jurors are picked, they follow a process that's called voir dire. Voir dire, of course, is, and if you've ever been on jury duty, you've been through this. You see how people get pulled out in groups and you're just sitting there buying your time, or maybe you even got invited into the courtroom and the attorneys take turns asking questions, and they could be completely random questions because you don't know what the lawsuit is. And so then they may say, okay, do you have a music degree? Or are you currently in music school seeking a music degree? And you say, yes, I am. And they'll say, okay, you're dismissed, goodbye. And you can go home. Or maybe they want that. Maybe they want to keep you. So each attorney has a set of questions or a limited number of questions they're allowed to ask. And each attorney has a limited number of people that the potential jurors are allowed to dismiss. The goal in a music copyright lawsuit is to pick jurors because of their lack of musical knowledge. So that doesn't just mean like their lack of being able to read notation or to have good oral skills. It also means their awareness of pop culture. So for example, in the Blurred Lines case, there's a specific juror who did not know who Pharrell Williams was. And that for the attorneys was like, jackpot. Yes, we want you, because they don't want the jurors to bring in any kind of external opinions about the performance. Maybe you think Pharrell Williams is amazing and you could never possibly imagine making him lose a lawsuit, or vice versa. Maybe you hate him. Maybe he is the worst musician to you ever, and you would delight in saying he never comes up with any original content, and this will be the day that I resolve that problem as a juror. We don't want those jurors. We want people that don't actually know what's going on as attorneys. But that creates a problem for forensic musicologists. How are you supposed to talk about music with people who are explicitly picked because they don't know anything about music? This is a challenge. Now, the other thing to keep in mind is that the standard for evaluating infringement is supposed to be a hypothetical lay listener. So as a juror, what do you think an average ordinary lay listener person might think? The problem is, and attorneys know this, often jurors will just insert their own opinion. Oh, I'm an ordinary person. This is how I would resolve. They're not supposed to do that, except they do. So often the whole fact finder lay listener thing gets conflated, which is why now often the people that get picked are non-expert ordinary people, because they're going to decide based on them inserting themselves as the ordinary listener. So that's our first issue. The next thing to think about is that recent studies have demonstrated that jurors or people put in the same conditions as being on a jury can mistake nearly identical melodies in terms of pitch and rhythm as not similar. If all you change is the timbre, the key, and the tempo. And we know in this class, one of the good strategies to use is to take your two melodies if they're in different keys, transpose one of them to get them in the same key, or adjust it so that we don't have to deal with things that don't necessarily indicate similarity or difference, right? Try to resolve those kinds of problems in our reports. So we're going to actually do an experiment here. We're going to recreate the experiment that led to this conclusion. So if you'll give me just a minute to click through. We have another song pairing. So this is based off of the green or second melody that we listened to earlier. Now, in this particular study, and we can talk about experimental design all day long, it's not a perfect study, but that's what we have. So we're going to take these melodies and we are going to run them through. Now, in the study, it was run through Sibelius. I recreated it in MuseScore. I don't know if that matters for you, but that's what I ended up doing. Anyway, we're going to take the melody, we're going to run it through MuseScore or Sibelius or some notation program. We're going to play it as it's, simplified, no harmonies, no nothing, just the melody. And then we're going to create a second recording that only changes the key, the tempo, the timbre. I could have gone through and changed the style a little bit, but I didn't. And then you guys tell me, are you distracted? Does this sound like a different song? So we're going to listen. We're going to do another pairing. We're going to recreate this experiment that revealed a large number of non-experts actually said these two songs, these two examples, they're different. when actually structurally they're not. Okay, so again, that melody is a pared down version of the green or B melody that we heard earlier. Now, here's what happens when I change timbre, key, tempo only. So you're probably not fooled by this. You're probably thinking these are the same melodies, which actually technically they're not. I went through and changed 3 pitches and 1 rhythmic duration. So they're not precisely the same. But in this study, that's exactly what they gave to mock jurors. And over half of them said, absolutely, those are totally different songs. So this is interesting and somewhat challenging for us as forensic musicologists, because we know if we play a melody on a guitar and we play the same melody on a trumpet, it's the same melody, right? All that's different is the timbre. And yet, non-expert fact finders might be distracted and absolutely say, yes, those are totally different songs. They're not necessarily going to focus on the thing that we want them to focus on. So this, of course, reveals a lack of predictability among our expert fact finders, but it gets more exciting. So the last idea here is that there's another study that, so you can imagine from this little experiment that we just did, you can imagine that all jurors are different, right? Everybody perceives music a little bit differently. Everybody makes sense and compares differently. And that jurors, of course, can and do weigh all evidence in a lawsuit, not just what they're supposed to be thinking about. They're not just looking at the expert evidence and the expert analysis. They're also thinking about testimony from the artists, other elements. They're looking at what the attorneys look like, what the songwriters look like. There's a lot of different details that jurors can take into account. Now, there was another recent study that went back and looked at previously litigated lawsuits. So lawsuits that are finished, including the one that we're talking about today. They go back and they say, okay, let's run the melodies through a computer algorithm, see what the computer comes up with as the quantity of similarity. Then let's set up mock jurors and relitigate the case, go through the whole argument, go through the comparisons again, and see what a new jury would come up with. So we've got the decision in the case, we've got what the computer thinks, and we've got what a mock jury thinks with the same comparison. The research revealed that the 2 juries, the real one and the new one, agreed only some of the time. Only about half the time did the 2 juries actually agree. And sometimes they even disagreed with the computer. So jurors don't actually even agree with computer algorithms. And so what this research demonstrates is that fact finders are extremely unpredictable. And that influences how we produce our evidence and how we produce our reports as forensic musicologists. How are we supposed to communicate to a group of jurors that we don't know until we're sitting in the room giving testimony? How are we supposed to explain music to them when we know that they're incorporating a lot of different musical information? They're not just listening to what we're saying as experts. They're not just trusting your beautiful, beautiful transcription to tell them, is this similar or is this not? And they can even get distracted by things that they shouldn't be listening to. So we have to think a lot about how we communicate our ideas to our non-expert fact finders. Imagine trying to explain lead sheet notation to a non-expert listener. We can read a lead sheet, that's fine. We know what the chord symbol means, but there's multiple ways to voice a chord. How do we get a non-expert listener to understand that a different chord voicing is the same harmonic function? That's a challenge. And actually that question did come up in the blurred lines lawsuit. So the case that we've been talking about, my technology is going crazy. So the case that this came from is called Swirsky v. Carey. It's from 2004. So starting to age a bit more than I think I'd like to admit. This is the model that we pulled from our little comparison that we did earlier. And it was also used in the 2 research studies that we just talked about. So the facts of the case. In 2000, these 2 songwriters, Seth Swirsky and Warren Campbell, decide they're going to sue Mariah Carey and say, you stole your melody from us. So Swirsky and Campbell write one of those love songs for their group Escape. So we remember this. Cut it off a little early, sorry. And so they're claiming that Mariah Carey's song, Thank God, that should say thanks, sorry. Thank God I Found You was recorded a year later on the album Rainbow, that it stole from this Escape song.
Until you say my love.
Okay, and so on. So the case is actually really interesting from an analytical standpoint, and I really hope that you'll get a chance to talk about it more later in the semester, or you'll do a project on that. So I don't want to spoil that part of it. But it's also interesting because the case reveals these sorts of enduring suspicions around experts and what they can offer in a lawsuit. So there are issues with both parts of the infringement test, and not just with the non-expert listeners that we just talked about. So in any case, why do we care? Why do we care about this case? There was a famous forensic musicologist. His name is Robert Walser, or Bob Walser. At the time, he was working at UCLA. He is now at Case Western Reserve University in Cleveland. But in any case, he analyzes the 2 songs exactly how you might imagine he would have, or how you might in your own heads. And here's what he says. He points out that the choruses in both songs share the same basic like contour or shape and pitch emphasis. They have similar chord progressions, similar harmonic progressions, and they're sung in a similar style with a similar tempo, and they're both in the same key. So they're both in B flat. Okay, so that's his interpretation, whether or not you agree with it. That's what he says. Now, it goes to the trial court. The trial court says insufficient evidence, because when Walser gave his analysis, the diagrams that he included were reductive. So when he did his transcription, he cleared out all of the vocal ornamentation, or what he calls appoggiaturas and melismas, the vocal acrobatics that Mariah Carey is really well known for, and they're kind of typical of the style that we heard in both recordings. He cleared all of those out. He cleared out and used lead sheet symbols to represent the harmonies instead of showing what the chord voicings were. And so for that reason, the district court said, you know, we can't include this. This is beyond what an expert witness is supposed to do. They're supposed to just do close comparisons as you hear the song. Okay, so in the relevant case law, of course, the court is relying on Arnstein. They're relying on this idea of what an expert is supposed to contribute and how they're supposed to go about doing it. And remember, expert witnessing and expert testimony is supposed to be objective. And so this district court is saying, if you clear out all those ornaments and you're reducing all of the harmonic structure, that's no longer objective, because you're introducing your own interpretation of the piece of what's structural and what's not. And so it's no longer objective, it's no longer good, we can't use it. Okay, so the expert testimony gets reinstated on appeal. So on appeal, the higher court says, no, it's still a valid method. It's still focusing on musical structure. Absolutely, this is part of the case. And so they, like in Arnstein, reverse and remand. They send it back to the lower court. And then by 2006, the case ends up settling out of court. But it's an interesting conversation about what we're supposed to be producing as expert witnesses and how it gets interpreted by these non-expert fact finders, both the judges and the jurors. Now, I have an example for you from the expert report. Now, this and the quality of this is the way it is because I Xeroxed it. I actually went to the court where the records are held in San Bernardino, pulled the originals and Xeroxed them, which at the time was 80 cents a page. They've since increased the price of Xeroxing from court records. So not a cheap endeavor if you're thinking about going into studying court records. In any case, if you take a look at, you can see Robert Walser's process for transcribing both melodies and how he cleared out all the ornamentation. And so these are supposed to be structural melodies with the lead sheet harmonic notation. You can also see that he's added in the scale degree numbers or pitch numbers in order to allow for comparisons as well. So the escape melody is on the top and the carry melody is on the bottom. So this is what was originally dismissed by the district court, reinstated by the appellate court. So if you take a look, you can see how the melodies differ considerably as to pitch. But do they actually have a similar contour? I don't know. What do you think? And this, of course, is a question for everybody. So Joe, please feel free to jump in as well. Do these melodies look like they follow the same contour? Does it look like the harmonic progressions are the same? What do we think? And based on our own oral analysis from earlier.
It's a great question. We can see the score for your info really clearly in the room. It's well up on the screen, so I think everyone in the room can see the full notation despite the Xerox thing. So let's just give the class a minute. You've got all your Berklee training, your core music theory. What do you think? Do you think these melodies are fundamentally similar? I mean, you can see where the notes actually literally line up.
The chord progressions are the same, except for the turnaround at the end. And the first measure of the melody is pretty much the same.
Yeah, so we've got this da, 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 on the beats 3 and 4 with the B flat sus4 chord. I'm always interested in partisan musicology, as you know, as we've talked about, and it's been an issue ever since Arnstein, hasn't it? The idea that you know, is the musicologist biased in favor of the person that is paying them? I wonder whether Walser has been a bit mischievous in bars 4 and 8, because that screams to me in the Escape song C minor 9, right? But E flat major 7 over C, which, as everyone knows, is from harmony, right, is another way of saying C minor 9, right? But of course, when you then put it into a visual medium like this, it looks like 2 aligned chords of E flat major 7. And I suggest that Mariah Carey meant E flat major 7, and that the Escape writers meant C minor 9. I mean, it's a legit substitution to say E flat major 7 over C is C minor 9, but it's an odd thing to transcribe, considering earlier in the song they've used A minor 7, G minor 7, and suddenly they come up with this slash chord substitution. I mean, it could be coincidence. It could be just that Walser's house style is not to use substitutions when chords go beyond the octave, which is a not uncommon thing in jazz. But functionally, I think in songwriting terms, that feels like C minor 9 to me, which would suggest that Walser might be accused of manipulating the chord chart to make the songs look more similar than they are. So that was a methodology thing that leapt out at me. Any other comments? Go ahead.
I have a question about access, about whether Mariah Carey had access to the Escape songs.
Okay.
Just seeing how big those people were.
This is a good question. Do we have any info on that?
Off the top of my head, I don't recall. If she had access to that, it's possible. That's something that would be explained in the court opinion. And although I read it recently, I don't recall immediately if she had, that was a another dimension to the lawsuit.
But it was a hit, right? So we
Yeah.
infer access because it was out there.
Oh,
Right, so it was
Right.
out, Escape song was out there as a single, it was in the world, right?
Yes, it was out there for sure. I don't know. It wasn't the point that the court focused on.
Right.
They get really stuck on Walzer's analysis and whether or not it's valid.
Okay, let me ask the class one more question, then I'll let you move on, because we've talked a lot in this class about whether something is more likely to be independent creation or copying,
Yes.
right? And it seems to me that a lot of the courts don't consider the possibility of independent creation as much as they ought to, as much as they might. So this is, now that you've looked at the notation and you can see note for note where the similarities and dissimilarities are, does that help you to infer whether this is likely to be independent creation or copying? So thinking about the composer of this second melody, the fairy melody, do you think if you're jamming along on a B flat chord and you're trying to write a mid-tempo R&B ballad, are these the kind of things you just might do that are in the zone of Escape? Or if you're going to write a melody like Kerry's, do you need to hear that Escape? So just consider that question for a minute, and then maybe we'll do another experimental vote and then hand it back to you, Dr. Leo. So, so thinking about that question, do you think the similarity is likely ascribable to independent creation or to copy? What's the more likely explanation for the subjective similarity? And then we'll maybe come to whether that's even a question that forensic musicologists are allowed to address. So looking for a vote, two-way vote, you're either going for the independent creation camp or the copying camp, right? I'm going to vote. Ready? Show of hands for independent creation. Okay, I think that's 6. Show of hands for more likely copying. Slightly more, so about as divided as we were at the start. Okay, Dr. Leo, back to you.
Now, another, if we could check again, did anybody's opinion change now that we've looked at notation? Okay. Yeah, because sometimes when our ears, it gives us different information than if we're looking at notation, right? It's a totally different situation for sure. Okay, so absolutely fascinating. Yes, I should look back at my notes because I've lost where we're going here, and I have a vision in mind. So there were other diagrams that were included in Walzer's report. He did like a baseline reduction. So there's a separate diagram that I didn't include in the slides. It's just the baseline with the harmonies underneath it. The court gets very upset about that because it completely excludes the melody. The question here, of course, since we've had this really interesting conversation about the difference between note by note similarities or congruences versus generic contour. And we've talked about how we represent a chord. Is it, what's the actual identity of the chord? You can see how in transcription, we can kind of let a little bias sneak in. And so there's some questions in bars 4 and 8 about how Robert Walzer is actually hearing this versus how he's representing it. The big question here, and this is really where we can start opening up our discussion, how can musicologists, given these issues, how can musicologists actually use an analysis to help the fact finders? So are we going to have, for example, we were talking about the harmonic, the chord quality, the identity of the chord. Is that going to be meaningful to our non-expert fact finders? And if it is, how can we help them out in understanding that? How can we communicate these ideas better? So I'd love to hear from you.
Okay, can we help frame the question? What kind of palette of how are we working with?
So we're writing a report. We're trying to explain whatever opinion we have. We're pretending to be Robert Walzer. We're trying to get the fact finders to hear what we want them to hear. Now, of course, our analysis is supposed to be objective. That said, Robert Walzer is also being paid by the plaintiff. So you're working for the plaintiff, right? So you're thinking already, yes, I think there's probably some similarity here. Yeah, this might actually be some infringement. Fine. How can we communicate information effectively? And what kinds of information do we need to give fact finders to help them make a decision about infringement? What are the kinds of things that they need to know? And how can we explain it in ways that don't require a music degree?
Right, great question. Now we've looked at some of these methods. Remember I talked about epistemology, that how shall we do the knowing? So how have we, in the examples we've looked at, particularly melodic examples in this class, how have we proved to our own satisfaction whether something is more likely to be independent creation or copy? What have we done? So one thing obviously is we've just done straightforward melodic transcription, but that just tells us the consonant notes. What else?
Yeah, put them in the same key.
So key compensation is one thing we can usefully do. And that helps us, as we've discovered, because it nixes the jury's possibility of being biased by a key change when we know a song can be in the same key and still protected by copyright. Teo, did you have a point?
I wanted to
Oh, so,
say that.
okay, right.
I'd see if other songs use the same exact.
Right, repertoire.
Yeah.
And this is a really interesting question that I hope we get into. That is, to what extent is the role of the musicologist to identify that prior repertoire? It seems to me there's a whole lot of things that go da 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 da, you know, 1, 5 with whatever substitutions you want to do for those chords. That doesn't seem like rocket technology to me. But we've done that a lot in class, haven't we? We've looked at prior repertoire from which we infer independent creation to be more likely. So key compensation, prior repertoire research, melodic note for note comparison. Anything else? We've got some big ones there.
I think we haven't done this, but I noticed like the numbers under the melody. I think that's pretty easy to like translate to people who maybe don't understand notes, whatever. I don't know. Yeah.
Right, really great point. So the microphone's across the room, so I don't know if you heard that. RJ's point was that we're looking at using note numbers, so degrees of the scale, 1, 1, 2, 3, 3, all of that stuff. Will and I were having this conversation just the other day of like, should we really put solfege in our report? And then we thought, no, let's not do that because it's jargony language for a non-musician. But certainly 1, 1, 2, 3 intervals of the scale, that's another helpful way we can demystify to a lay audience maybe. So how do we do, Dr. Leo? Do we miss any?
Pretty great. Yeah. So the big broad picture word that I think about is relevance. So as forensic musicologists, we're not just going through and doing the detailed comparisons, note by note, and we're not just doing transcription. That's only part of the process. The second process is relevance. This is where prior art comes in, the prior repertory. Yes, this melody is similar, except it shows up in 5 different places in different genres of music over a 50-year period. So is it super relevant? Probably not. Versus, yes, this melody is similar. And in this section, there's a really unique gesture that doesn't show up anywhere else. So the fact that it's copied in both is probably significant, right? So it's not just, is there similarity, but does it matter? And why it matters, right? So we're thinking carefully, and we're trying to find ways to communicate that as well. So do we really want to use solfege? Probably not. We can leave the jargon to the judges and their court opinions, but as experts, we want to try to communicate as clearly as possible. Numbers are a great way to do that. Expert musicologists have been using numerals, scale degree numbers, since the 19th century. So this is very common. Another technique that's very common is to use color. So to color code sections or to mark off similarities using red or green or whatever. Musicologists all the way into the present day do this. And that helps to draw the eye toward a particular section that is meaningful. Some musicologists have also used letter names. But again, if you have no musical knowledge, is the letter name really any more meaningful than the solfege syllable? Probably not. So it's an important question. When we're thinking about audience, we have to communicate in a way that's meaningful to them, right? Not just what was meaningful to us, not, hey, look at all this hard work I did. That's great too, but why? And who needs it? So our final thoughts for today, the test. Let's get back to this Arnstein test. It's kind of convoluted, and we know that it's built on faulty premises, right? We know that it's assuming that listeners listen in a sort of holistic way, and they don't. We've discovered that through psychology research. And we know that experts aren't allowed to have a final say in anything. They can't say, yes, infringement. All they can say is, yes, copying, and hey, look what's interesting about this, what's relevant about it. So how do we fix the test? How can we tell the courts, this is the test you should be following that'll help you get more consistent results, more reliable results, results that protect songwriters' property better?
Question. So I think this class, as we now spent 2 weeks talking about Arnstein, we've got a good idea of what the flaws are in that methodology. From the examples we've looked at today, we're getting an idea of why juries of non-expert listeners can come to the wrong conclusion. Should we be redesigning this test? How can we help courts to come to the right answer? It seems to me that a lot of times when you hear people going online and tweeting about Olivia Rodrigo ripping off Taylor Swift and so on, they are hearing, and we've talked a lot about this, commonplace elements, right? So I suggest that one thing that we might usefully bring into the test, and I'd be interested to get your view, Dr. Leo, on where we are, where the courts are with this, that it seems to me that the most common explanation for a spurious plaintiff is independent creation, right? These melodies are similar through coincidence just because both parties are doing a commonplace element. So really two issues. One is how can we prove independent creation through repertoire? And two is how do we get juries to stop listening to commonplace elements? As this class knows, my favorite example is my EDM track starts with a 4 on the floor kick drum, and so does yours. You copied me, I'm going to sue you. Now, everyone in this class knows how ridiculous that is, because to everyone in this class, an EDM kick drum is part of the basic building blocks of dance music. But why would a jury know that? And how do we? So to me, those are the big problems, and we've explored some of them in class. Of how do we get juries to discount commonplace elements and tell them what they are in our expert testimony? And more nebulously, how do we use older repertoire research as evidence that this is just the thing that songwriters might do, coincidentally, independently of each other? And a really recent example of that I love is Gray v. Perry, because it's, and I'll just, well, we've got the audio on because I'd be interested to get your take on this. I will key compensate them both into A minor, but when the keyboard comes on, it's versus I remember the last two notes were dissimilar. I'm maybe messing that up slightly, but basically, this class already knows that a lot of songwriters might play 4 to the bar, hitting the minor third of the home key and just one finger keyboard melody. A jury can't possibly know that that's something a songwriter might do. They'll just hear a similarity. So, and we've explored these questions in some detail. So forgive me hogging the floor there, but I'm trying to summarize 7 weeks of discussions we've got into here. But so that's my question back to you. Is there an opportunity to do more about repertoire and therefore independent creation investigation? And can we somehow use our reports to deprogram jurors to stop listening to commonplace elements?
So huge question to unpack there. Let's see if we'll work backwards some. So as far as I know, there is no way to deprogram the jurors. They are going to do what the attorneys select them to do. And jurors are notoriously unpredictable because they look at things like what the attorney wore that day. Did they consider the witness trustworthy or not? Are they supposed to do that? No. Do they? Yes. And sometimes that's a subconscious process. And we make these sorts of snap decisions because it's humans looking at other humans. So that's a problem that we can account for, but we can't actually solve. And we can only account for it so much. We know it's happening, but we don't know exactly how. So there's that part. Now, there's a lot of different suggestions on how to fix this test. Specifically for the jurors, there have been a number of scholars who say, you know what, the problem is actually the lay listener standard. Why don't we just elevate the standard? Why don't we switch it to a discerning observer? Someone who actually has some musical knowledge. Maybe that solves the problem. Some of you are nodding your heads like, yes, this will problem solved. Like, let's just narrow the jury pool to people who have some knowledge. Other versions of this are a target audience. So who was Xscape supposed to be, like, who was their target audience? That really actually limits the jury pool considerably. Among people that listen to this style of music, are they actually going to mistake Mariah Carey's voice for Xscape? Maybe, maybe not. But that's a different comparison if you're really familiar with the repertory and the style than if you are a lay listener who doesn't know who either of these artists are and never listens to the music. So there's intended audience, there's actual audience. Let's go find people who actually bought the albums, and then target audience. Who did we, which is kind of similar to intended audience. So that's an option that scholars have proposed. The discerning observer test is something that has been used in the Second Circuit a little bit. There's two cases that kind of go together. One's with Kanye and another one's with Beyonce, where they use the discerning observer test in order to make a little bit more sophisticated arguments. But it's not something that's replaced the lay listener concept. That's still pretty much the foundational idea, or what you might also see it as the ordinary observer. In terms of adjusting our reports, that has to do with the relationship that we build with the attorneys. So we need the attorneys to ask the experts questions that allows them to talk about prior art more in front of the jurors. So there's not comparatively less control over what goes in our report or what doesn't, how many examples you can use, how long your report can be. Jurors don't read those reports. They hear testimony. And so it's important to get the attorney to understand, this is what matters. This is what you should ask me about, so that I can explain it to the jurors and get them to hear the way I would like them to hear. Now, another suggestion that some of you might have thought about, what if we just eliminate the jurors altogether? Why don't we just trust the musicologist to do it? Some of you are like, yes, this is a great plan. Musicology.
I can tell you there's a frisson in the room when you said that. What do we think? Would that solve it? Would it bring any problems that you can foresee?
Maybe some biased opinions toward like certain musicians.
Right, so we might end up getting bias, and that bias in a jury-less world would come from unscrupulous musicologists doing what their paymasters wanted them to do. And those people exist in the world, right?
They do, unfortunately. Yes. Yeah. So that's a problem. It's not necessarily a foolproof solution. It also doesn't cope with that economic issue. Remember, the whole purpose of copyright is to protect your economic interest. So we're not actually, if we eliminate the lay listeners, we're not representing the market anymore. Unless we elevate the test and say target market or target audience. And that's musicologists. So that's a little bit of
and we, because we have so little time left, I would maybe we can use a couple of moments exploring this, because uniquely in the US, I believe, jurors decide how many dollars the damages are, right?
Mhm.
Now, in Gray v. Perry, so as we know, six note lick of 8, where there were some pitch similarities in what, in my opinion, is independent creation. I think the settlement was $4 or $5 million, something like this, that eventually that the jury awarded. It was eventually overturned on appeal, but the point is that the jury would have decided on what that amount was based on evidence in discovery of how much the Katy Perry song had made. But what seems to me is the flaw in the argument here is the idea that the Christian rapper Flame lost $4 million of his royalties because Katy Perry had a similar synth lick. That seems like an absolutely implausible, and I know it's one of the 4 tests for damages.
Right.
But the idea that because someone uses a melodic lick, you're gonna stop buying that old record and buy the new record that has the same lick, said no consumer ever. So that economic argument, is there an argument that the jury also has no role in awarding damages because it requires reductive dissection of the value of a musical element?
So I have not encountered research from legal scholars or musicologists that have suggested that. But I think it's actually really fascinating that maybe the problem, sure, lay listeners can decide whether or not it's similar or not. But when it comes to damages, that's where we need to talk to the experts. And they shouldn't be deciding that. That's an interesting idea. I actually like the idea that was proposed by one legal scholar, copyright specialist, who said, why don't we just flip the test? So we can't really get rid of the lay listeners because of the economic issue. Why don't we just flip it? Why don't we ask the lay listeners at the start of the lawsuit, here's the recordings, make just a snap judgment, and then let the experts come in and talk about it and break it down for you and explain why this is probably infringement or probably isn't. And then the jurors see if their minds are changed.
So the jurors would still get the final say, but they'd have the chance to be influenced by expert testimony.
That's what the scholar suggested. In my mind, I think we just let them give the quick decision. The experts come in, they give a recommendation to the judge, and the judge is actually the last person, final say. In my mind, in my perfect world, it doesn't exist. Part of my thinking is because they've done a lot of psychological research on judges, and they found that judges are shockingly immune, not entirely, but mostly immune to bias, because they've trained for so long to be unbiased, to take a systematic approach to making decisions, to having to deal with difficult decisions that change people's lives. They are less prone to feeding into the kinds of things that jurors might feed into or that attorneys might feed into. And so I think the final say goes to a judge, but absolutely we should have that representation economically. And we should let the experts talk a little bit more than we do currently. I think they should be allowed to say yes, infringement, no infringement.
Right. Well, I don't want to bring any cultural imperialism to America, but that's how the Brits do it. Just judge and experts in a room behind closed doors. But that is a very strong argument. So we're coming to the end of our time, unfortunately. This has been really terrific, and I want to sincerely thank you for bringing such a depth of scholarship and consideration to these questions that have been foxing us track by track for 7 weeks, and will continue to do so. Any sort of closing remarks or thoughts you want to lead us to, or extra scholarship we should pursue?
Well, I hope you all take a minute to read my book, couple minutes, because it's a little dance. But I hope you really embrace the excitement and the fun of forensic musicology. It's always a challenge. It's always interesting. It's challenging, but it's good work. So as we're working as forensic musicologists, always think about who you're writing for and who you're talking to. The audience is the thing that matters. We don't write for ourselves. We write for other people to read, and we speak for other people to listen. So always think about audience.
That's a pretty good maxim for life as well, I reckon. So in that case, can we just take a moment and thank our special guest, Dr. Katherine Leo.